bill. We seek your guidance. At this juncture in our nation, we definitely need your protection, your guidance, and your wisdom. And so we ask that you will now intervene in these proceedings, and may everything that is done here be done to your name's honor and glory. Amen.
Thank you very much, MP Donovan Williams. I was hoping that Minister Williams would be here at the start, but I just spoke to her. She's trying to get here soon, but we have just one or two matters that we can do before we get to the Child Care and Protection Amendment Act. Firstly, we look at the minutes of last week, Wednesday. Before I go there, we have one apology, MP Tamika Davis. And I should also indicate that we have online Senator Shireen Golden Campbell and also Senator Charles Sinclair in Montego Bay. I know Senator Shireen Golden Campbell is abroad. And we also have joining us Ms. Chantal Bailey and Monique Adams and Charles Young from the technical team. Let me also welcome the technical team, members who are here at our Attorney General's chambers, the Ministry of Education, Ministry of Justice, CPC, and the OPC, Law Reform. Okay, so we can go through the minutes now. There are a few slight corrections, but more just typographical. Any suggested correction, members, that you see?
I just have one to clarify on page 9. In the second paragraph that begins with Senator Golden Campbell, and I'm glad she's online. It says Senator Golden Campbell asked if a sentence of death was a life sentence.
I think the idea was how it was asked if it was normally converted to a life sentence.
Yes, Mr. Chairman, you're correct in that.
Right, thanks.
Okay. My question was to determine whether or not when a penalty of death was handed down, what practically happened, whether it automatically converted.
It's not so much automatically as I responded. It's usually, you know, when it goes to the Court of Appeal or sometimes the Privy Council, they might find that the sentence, say in Pratt and Morgan, it passed the 5-year term, and oftentimes, in a few cases, the Privy Council have ruled that they convert it to a life sentence because the death penalty should only be imposed in the most egregious cases, and they enumerated a number of factors before they would, you know, support the death penalty being affirmed. So it should put Secretary asked if the death penalty was normally or usually converted to a life sentence. To a life sentence.
Right. That was my clarification.
All right, thanks. So that's one clarification. There's also one, too, that affect the meaning at page 3. The third paragraph that ended indicated that persons might insist on proceed to trial if a sentence was, it shouldn't have was lenient, was not lenient. He indicated that persons might insist on proceed to trial if a proposed sentence was not lenient, right? If a proposed sentence was not lenient. In fact, as you can see, what Senator Scott Motley said supported that point. That yes, I'm going to give it this. Go ahead. Sure. Sorry.
People would express their disappointment of same and it opened. I'm suggesting you put up. You insert up at that stage. So it would open up the possibility of revenge.
Exactly. Opened up.
Yes. And then at the paragraph below, where it says that people reacted to plea bargain in a certain matter because they wanted, what I said is they wanted to be sure of a lesser sentence.
Right.
And attorneys did not, and then where she commented that she did not understand the psychological difference created by certainty with pleas, it's not and, it's but.
But attorneys will mention that invariably instead of and, okay?
Yes, that's...
And as I said, the end of the previous paragraph, if a proposed sentence was not lenient.
Yes, definitely.
In the middle of the paragraph too, just grammatical, he added that the process for amendments to legislation had started and there were many legislations, were instead of was.
And I was thinking when I read it that if we put there were many laws rather than many legislation.
Yeah, there were many laws, right, many laws instead of legislation.
Yes.
All right, but thanks, Secretary. The minutes are usually very comprehensive and, fairly accurate. So I'll ask for a confirmation. We'll have Senator Scott Motley proposing, seconded by Senator Gill. All right, so we do welcome Senator Binns, and as I say, we have two other persons online. What we're going to do is a simple one first, to deal with the Criminal Justice Administration Act. And in that, the main proposal is, we can see in subsection 2, section 42E. I hope members have that copy. That is the proposed amendment to the Criminal Justice Administration Act. It's consequential on what we have been doing. So section 42E of the Principal Act is amended in subsection 3 by deleting the words, the prescribed minimum penalty for the offense as provided for pursuant to 3(1)B of the Offences Against the Person Act and substituting therefore the words, we had 30 years. Mr. Bailey and SG, in light of the, we had proposed the minimum, this is for non-capital murder. We had moved to 30 years, you remember? For non-capital, either life sentence or 30 years, agreed? So that is okay for us to, the problem we have is all right, so subsection, or section 3 says, section 42F of the Principal Act is amended by deleting the words, a term of life imprisonment shall be deemed to be a term of 30 years, and substituting therefore the following, a term of life imprisonment shall be deemed to be a term of A, 50 years, where the offense is murder, or B, 30 years, where the offense is an offense other than than murder. I think 3 is okay, but is section 2 consistent, SGN, in light of what the adjustment we made last week to non-capital murder? Yeah, Mr. Bill.
So, Minister, to point out the provision as it stands now in the Act, what it does is that it relates the minimum to what it is under the Offences Against the Persons Act. By virtue of the amendment that we are proposing, it might be that it is no longer necessary because we have already proposed 30 years under the Offences Against the Person Act to be the minimum. And since the provision as it stands under the Criminal Justice Administration Act refers you back to the Offences Against the Persons Act, there is not a need for an amendment.
CPC, would that be correct?
That's correct, Chair, but the bill as currently tabled had actually reduced rather than kept the status quo. So if that policy is still being pursued, you would have to then drop it, unless the decision is to go back to the status quo and retain the same sentence that currently exists under OAP.
All right, remember last week we, by consensus, agreed that for non-capital murder, it's life imprisonment or a fixed term of 30 years. With, if it's life imprisonment, the minimum mandatory is 30 years. Agreed? And if it is a fixed, the alternative 30 years or 20 years, correct? Right. So CPC, in light of that, what should we, is subsection 2 of the Criminal Justice Amendment Act necessary?
If you're keeping it at the 30 years, then you could simply just leave the provision that currently exists in criminal justice, since it already cross-references the OAP. So you wouldn't need this amendment here if you're keeping it at the 30 years.
So subsection 2 would not be necessary.
Right.
So we bear that in mind in our report. Okay, if Parliament accept our proposal, the consensus that we arrived at last week, then subsection 2 may not be necessary. We would just delete it. Yes.
But it then raises a policy question as to what the appropriate sentence should be under the Criminal Justice Administration Act, seeing that the regime is really about giving a credit for pleading guilty.
So you see, I accept that. So if the person pleads guilty, the sentence could be 30 years, or they would get up to a third concession. Isn't that right?
Minister, because what 42E is stating is that the judge cannot go below this penalty. So the judge cannot go below 30 years in sentencing that individual.
So that's why it was there, the 30, because we were proposing 45.
45, correct.
So that is why if we remove it, then there's no problem.
No, there would still be a problem, Minister, in the sense of there would essentially be a dissonance in the policy.
No. If you don't have subsection 2, then the OAP Act would apply where the sentence proposed was 30 years. Yeah, what's the concern with it, Bailey?
Minister, my concern is that an individual pleading guilty would not necessarily benefit from a real reduction.
Yes, because the sentence proposed by us is 30 years. So they could benefit up to a third, and it would reduce it to 20 years.
Because if we establish the minimum to be 30, that...
No, remember no, that is the proposed penalty for non-capital.
Right.
And that is the proposed sentence, minimum, agreed? So if the proposed minimum is 30 years.
You set the 30 years being a threshold. That threshold also allows that if someone was to plead guilty, there can't be any negotiation below that minimum threshold.
If they're coming under the criminal...
Yes.
Okay, so it's clear to me then, Mr. Bailey, the 30 should really be... Go ahead, SG.
Sorry, Chair, perhaps you would just, I always think it's always good to read the existing law and then you read what is being amended. Right now it says, notwithstanding subsection 2, the court, I hope I'm reading the right thing, the court shall not impose on the defendant a sentence that is less than the prescribed minimum penalty for the offense as provided for pursuant to section 3 1B of the Offences Against a Person Act. And what you were changing was to take out the words the prescribed minimum penalty. So what it was saying is that the court shall not impose a sentence that is less than the prescribed minimum penalty. But you'll recall that the existing prescribed minimum penalty under 3.1b is 15 years. But you were moving the prescribed minimum penalty from 15 to 45 before the committee took a decision. Right. And so the policy was that you would have this provision speak about, not about the prescribed minimum penalty, which would have been 45 years, but a lesser, a reduced amount, which would be 30 years. So the issue is, do you want to retain that policy or not? Which is what the CPC was asking.
I think,
do you want to retain the policy, or are you changing the policy?
It's clear to me.
If we don't do any amendment, it will go back, it will just be that it is the prescribed minimum penalty. The court shall not impose on the defendant a sentence that is less than the prescribed minimum penalty, and now, based on the decision of the committee, that's 30 years.
Well, it seemed to me that is what would apply, save and except that we had also said that they must serve 20 years before being eligible for parole. So SG, what we're saying is that if we delete subsection 2 in this proposed amendment, fine, is that that would mean that we would go back to the original position. That's what I'm thinking. So we would propose a deletion of subsection 2 in the present act. So we go back to the original position.
You mean in the bill?
In the,
you would delete clause 2 of the bill.
That's correct. And the original position in the Criminal Justice Act would remain. Is that agreed? That's okay, Mr. Bailey, which is what we said. Huh? CPC, isn't that the position?
If the policy is to retain the existing position under criminal justice.
Right. So the end result is that the man could be sentenced to 50 years, but the judge would reduce it to 30 years because that's the minimum penalty. Okay? So that's a proposal. Is that agreed? We delete section 2, okay, of the present bill. No, clause 3 remains. So
I'm just trying to understand something. So what we're saying is that based on the recommendation that you've just made, Chairman, that the new dispensation, assume it is accepted when it goes to Parliament, is that under the Criminal Justice Admin Act, if somebody pleads guilty on the first appearance, then they would still have to get the minimum sentence as is provided under the Offense Against the Persons, which we're proposing to be 30 years?
That is correct. In other words, remember, that's the minimum sentence that would normally be proposed, so that, bear in mind, the custodials, because in section clause 3, if life imprisonment is imposed and the person pleads guilty and comes under, then we're saying 50 years is what would be considered life. So then the judge would use the 50 years in order to reduce the sentence. Now, when they plead guilty, say coming under the Criminal Justice Amendment Act, the judge has the opportunity to impose any sentence, but not less than 30 years. Okay? So the effect of pleading guilty, using without more, they would get 30 years.
Okay.
Bear in mind, we always have that caveat where they could negotiate.
Or the DVP can appeal.
Yes.
Chairman, just my understanding now, if the policy, when the bill came to us, was that if you go under the Criminal Justice Admin Act, that you would get a lesser term for pleading guilty under the Criminal Justice Act. We're then changing the policy now. At this moment, we're changing the policy to say whether you go under the Criminal Justice Act or you are found guilty under the Offense Against the Persons, the minimum you have to serve is 30 years.
No, bear in mind, let me just explain.
I'm just trying to understand, sir.
No, I understand. The original position now is that you could get a fixed term, but you must serve at least 15 years. What has happened is that we have said that the fixed term must not be less than 30 years. Fine. So the question under the Criminal Justice Administration Act, the term could be higher than 30 years. But if the judge says this would normally impose 30 years, which is the minimum possible, they would not benefit under the Criminal Justice Administration Act because they would be imposing the minimum. But if the judge said, I would have normally sentenced you to 50 years, then the judge could reduce it to 33 years, for example, but not less than 30 years, because we are proposing for non-capital murder, the minimum mandatory in the normal circumstances would be 30 years. Okay?
The reason for the change in the policy today would be because last week we agreed to a lesser period.
That's correct. That's correct.
Understand. Thank you,
Good.
sir.
Thanks. All right, so that's the position then. So we agree that we would remove clause 2. So no, clause 3 now become clause 2. Okay? All right, colleagues, we're hoping the Ministry of Education, I don't know if the technical team from the Ministry of Education had any instructions or can guide us, but the third bill which we want to finish up today is really one. Sorry? No, 3 becomes 2.
I was just going to suggest, though, Chairman, that you should actually have the committee take a decision on the renumbered clause 2.
Right, so that the position in clause 3, okay, is that an amendment to clause 42F of the Principal Act by deleting the words, a term of imprisonment shall be deemed to be a term of 30 years. So if the court would normally impose a life imprisonment, the court would start out at 30 years and then give whatever concession. So now we're saying you don't start at 30 years, you start at 50 years. So if you get a third, you could end up at 33 years, okay? This is consistent with what we have been proposed, increased penalties for murder. So if that is accepted, we would therefore propose that clause 3 becomes clause 2. Okay? Sure, go ahead.
Oh.
Go ahead, SG.
Sorry, but in A, you have not differentiated between capital or non-capital.
No, but to be fair, to the best of my understanding, it only applies to non-capital. The Criminal Justice Administration Act doesn't apply to capital.
Oh, that's right.
It only applies to non-capital. If you want, where the offense is non-capital murder, we could put it that way. But
well, we don't use the term non-capital in the OAP anymore.
Exactly.
It would have been using their language and more convoluted.
Right. So it should remain because it only applies to non-capital murder. Yeah, yes, Senator Binns, you had a concern. That's cleared up. All right. Thanks then. So that's the second bill. Now, in the third bill, which is the one that has, we will, hopefully we can deal with it. Members, could you pull the third bill, that is the Child Care and Protection Amendment Act? Now, I would just want to emphasize again where the child is between, I'm glad Minister Williams is here. So what we are going to start with this Child Care and Protection Amendment Act. And members will recall we have agreed where the child is 12 to 14. This bill is not dealing with them. They come on the different sections, and the court would make its decision based on the circumstances of the case. Okay, so that's 12 to 14. But the OAP, once the child reaches 15, they're treated, charged, and prosecuted and sentenced as if they were an adult. Okay? So the present position is that 15, 16, 17, they're actually treated under the OAP as if they were adults. Okay? What we're looking at here, colleagues, is because of the petitions from the different agencies, we felt that maybe we could look at a regime for them, okay? So I hope members will recall, all right? So in the proposed bill, you will see that in light of the discussions that we had, the proposed bill have been revised by the CPC, and I don't know if you have the revised amendments. If not, because you need a copy, because that's the one we're going to be looking at. It was circulated last week. We didn't get to it last week. Minister Williams, you have that? If not, let us get copies so members know what we're... Own it? Minister Williams, please just check and make sure. You have a copy, Member Williams? All right. It was actually sent last week. So what is being proposed by the CPC is that the long title should insert next after the words "and act to" the word "further." There's a further amendment being proposed. And clause 1 insert next after the word quote unquote amendment the words number 2. CPC number 1 was the one we had. Sorry.
So this becomes number 2 because there was another amendment.
Remind members
passed.
which was the first one?
The act removing the provision dealing with the uncontrollable child.
Ah,
That one.
okay. Yeah, that was number 1. Right. We passed that earlier, a month or so ago. Right. So this is now number 2. Okay. So clause 2, we're going to delete the clause, the proposal, and substitute therefore the following. Section 78 of the Principal Act is repealed and the following substituted therefore. 78.1. Except as provided in this section, a child shall not be A, sentenced to imprisonment with or without hard labor for any offense, or B, committed to an adult correctional center in default of payment of any fine, damages, or costs. Subsection 2, sentence of death shall not be pronounced or recorded against A, a child convicted of an offense, or B, any other person convicted of an offense, if it appears to the court that at the time when the offense was committed, the person was under the age of 18 years. 3, in any case where a sentence of death could have, but for subsection 2, been imposed, the offender shall, subject to subsection 4b1, be liable to be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act, the court on sentencing the offender may, A, if the offense is murder, specify a period of not less, and in bracket, which is a bracket we have to consider, colleagues, which is the position in the present bill, which the offender should serve before becoming eligible for parole, notwithstanding Section 3 of the Offences Against the Person Act, and B, in the case of any other offense, specify a period which the offender should serve before becoming eligible for parole. And a person so sentenced shall be liable to be detained in such place, including an adult correctional center, if the child has attained the age of 14 years, and on such conditions as the minister may direct, and while so detained, and shall be deemed to be in legal custody. Is it 14 years CPC or 15? I think up to 14, we said it shouldn't affect 14. So where you have included an adult correction, if the child has attained the age, shouldn't it be 15?
In the act currently, it's once a child attains the age of 14 years, 14 and above.
But to the best of my understanding, we're dealing in this act with children 15 and above. So
the current 78 subsection 5 talks about a child under the age of 14 years. So that this provision is consistent with that.
Well, I just want to be clear, because we're saying that up to age 14, this bill, sorry. I thought we're always saying under 15. In other words, to the best of my knowledge, the OAPA that imposes charge and sentence deal with children 15 and above.
No, it says where a child under the age of 14 years is convicted of an offense specified in the fourth schedule, and the court is of, should have said, the opinion that none of the other methods in which the case may legally be dealt with is suitable, the court may sentence a child to be detained for such period not exceeding 25 years as the court may determine. It's a child under 14, which means the child hasn't attained 14.
I don't know. I must admit, we have always, yes, yes.
No, sorry. Sometimes I think chairpersons are not very precise with their language, but the act is clear. It didn't say 12 to 14, it said 12 to under 14. But we all know that persons are very imprecise with language. All of us are.
But to the best of my knowledge, SG, if a child is 14, they're rarely tried as an adult. Is it, huh?
Can I also read from 78.2? 78.2 also talks about a child who has not attained the age of 14. So in both places, in Section 78 of the CCPA, it speaks about children who have not attained the age of 14. So if you're going to now change it, that is a change in policy.
Go ahead.
Yeah, so it would seem to me, Mr. Chair, that this issue of increasing the sentences for children between 15 and 17 then would have to be seriously looked at. We'll have to revisit it, since there would be a gap. There would be like a lacuna, in the sense that it seems that the legislation as it stands now contemplates under 14. So it would mean then that we'll have to decide whether we are now going to amend our previous position of 15 to 17 to 14 to 17, if you see where I'm going. Or, Madam SG.
Go ahead.
Or there's another option. Maybe you don't want a certain type of sentence to apply to children 14 to 17. That's the other option.
Mr. Chairman, might I be heard? I apologize because I'm not able to see how it indicates.
Go ahead, Senator Campbell.
Thank you, Mr. Chairman. Mr. Chairman, I just want to recall that the reason we came to this discussion about children under the age of 15 was because of the data which demonstrated to us that of the 3% of murders committed by children, less than 1% of that 3% was committed by children under 15. That's what the data from the Court Administration Services had outlined to us when we looked at the numbers between, I believe it was 2016 and 2022. So I'm clear on what the SG is outlining as an anomaly in the policy, but the policy, in my view, ought to be informed by the data. So it is possible that in previous iterations of passing legislation, we didn't have that data, or that numbers were different, the data was different at the time the legislation was enacted. We're looking at what is currently the situation and what are we doing from a policy point of view. I'm operating remotely, so I'm actually trying to pull up the CCPA, although I did hear what SG said. I wanted to take a deeper look at it. And I'm going to pause there, Mr. Chairman, with that said, and come back in a few minutes.
Sure. I think, members, we were operating on the basis that the child 14 and under would be dealt with totally different from the child reaching the age of 15. The view in all the discussion is that once you reach 15, then you would be treated like an adult. Is that my understanding always? So I would say that CPC, we're going to use the age 15, okay? So where we have here, which I just read, section 78(3)(a), B, and a person so sentenced shall be liable to be detained in such place, including an adult correction center, if the child has attained the age of 15 years. We will emphasize this. No, we're going to change. No, what SG said is that the Child Care and Protection Act did use the age 14, but for our purposes of sentencing, my understanding is that the present position is that a child is not normally tried in the Supreme Court, in circuit, unless they've reached 15. So they're tried. Yes, in other words, if we are going to be imposing sentences of 20 years, life sentence, because if the child up to 14 cannot be sentenced to more than 25 years, Okay? So we are now saying if you reach 15, you can be sentenced to life sentence, but you must serve a minimum. And this is where we want to do an adjustment as against the adult, because under the present law, a child 15 and above could be sentenced as like an adult. So what we want to do is to change it to say they must serve a lesser period, because at 15, 16, there must be some hope for that child. Okay? So I would say that in this legislation, we want to use 15 for sentencing as an adult, not 14. Okay? 15, 16, 17. Yeah, go ahead. Let's hear. No. There's really no gap, you know. The present law is that children 12 to 14, SG, correct me if I'm wrong. The present law is that children 12 to 14 cannot be sentenced to more than 25 years. Under 14.
It's under 14, and Chair, I just took the opportunity to look at the Juveniles Act, which was repealed and replaced by the Child Care and Protection Act. A young person in the Juveniles Act, a young person was a person who had attained the age of 14 and was under 17. And so that regime continued in the Child Care and Protection Act, where you talk about persons 12 to under 14, and then you had the 14 to 17. I just want to also point out that I'm not sure if you'd want to call it an anomaly, but if you're making the change in section 78, I think the committee should be aware that in section 72, you do have some references to a child who has attained the age of 14. And so I'm just saying...
Minister, this is your bill. What's your proposal?
That we go with the under 14 years.
Leave it at under 14.
Under 14, and then...
Okay, let's...
Then you have to be over 14 after that.
All right, I'm going to read it, and then we can get back to this, if necessary. So that, and on such conditions as the minister may direct, and while so detained, shall be deemed to be in legal custody. Subsection 4, where a child who is under the age of 14 years commits an offense specified in the 4th schedule other than murder, and the court is of the opinion that none of the other methods in which the case may legally be dealt with is suitable. Subsection A1, the court may sentence this child to be detained for such period not exceeding 25 years, which is the present position, as the court may determine. And 2, the child shall during that period be liable to be detained in such place, including an adult correctional center, and under such conditions as the minister may direct, and while so detained shall be deemed to be in legal custody. In the offense of murder, which is where our interest is, for which sentence of death could have, but for subsection 2, been imposed, and the court is of the opinion that none of the other methods in which the case may legally be dealt with is suitable, the court may sentence the child to be detained for such period of not less than nor more than as the court may determine. And subsection 2, Roman 2, falling within section 2.2 of the Offences Against a Person Act, and the court is of the opinion that none of the other methods in which a case may legally be dealt with is suitable. The court may sentence the child to be detained for such period of not less than, for us to determine, not more than, for us as the court may determine. As the child shall during that period be liable to be detained in such place, including an adult correctional center, and under such conditions as the minister may direct, and while so detained shall be deemed to be in legal custody. where a child who has attained the age of 14 years is convicted of the offense of murder, falling within subsection 2.2 of the Offences Against the Person Act, the court may sentence the child to be detained for such period of not less than as the court may determine, and the child shall during that period be liable to be detained in such place, including an adult correctional center, and under such conditions as the minister may direct, and while so detained shall be deemed to be in legal custody. So, you know, colleagues, I think this comes under the Minister of National Security because it's a correctional center matter.
It's the Minister of National Security who determines that? Where the child, where the child goes and and the conditions. So the minister actually takes a very active role in this legislation. I just wanted to know which minister would then.
I think it's the Minister of National Security because correctional institutions.
Well,
is in the Child Care and Protection Act, is the minister referred to is. Turn on your mic.
It's referring to a matter that falls within corrections. It would be the
Minister of National Security. Right. No, what has happened, colleagues, is that we are being asked to do some modification to the Child Care and Protection Act when, to be frank with you, our principal interests were really in the offense of murder. Okay? But because it affects matters, you know, under Section 78, we're being asked to determine other areas within the Child Care and Protection Act, which, Minister Williams, we will need some guidance from you, so that when you look Yes.
Just to be clear, we are only demarcating children who are under 14 years and those who have reached 14 years, who has attained the age of 14. So we're not
changing.
Right, and we're not trying to do 14 to 17 or any of that. We're just under 14 and those who've reached 14 years of age.
No.
According to this?
No, if you look at the last section that I read, subsection 5.
Yeah, it says where a child who has attained the age of 14 years.
Well, that goes to 17.
Right, so I'm just saying we're not trying to...
No.
Right.
Right.
So it's consistent now, the way it's written, in terms of the age, and there's no gap.
That's correct.
Okay.
Right. But what we are being asked to do, though, Minister Williams and colleagues, is if you look at the front page, that's section 78, subsection 3A. Now, this is just look carefully at subsection 2, because this is really dealing, in a sense, with capital murder, because it says sentence of death shall not be pronounced or recorded against a child convicted of an offense or any other person if the time of the offense the person was under the age of 18 years. So what it is saying, colleagues, is that all persons under 18 years, if they committed any offense which could normally be sentenced with death, death would not be pronounced, because at the time of the offense, it was the person was a child, under 18. So that what is being proposed, if the offense is murder, specify a period of not less than 20 years, which a child should serve before becoming eligible. So the idea there, to the best of my recollection, was that if the person had committed capital murder, then it could be life imprisonment, but not less than 20 years before being eligible for parole. Yes, Mr. Young.
Sorry, Chair. I don't mean to derail the current conversation, but I was wondering before we get into it if we could do some quick housekeeping. I just find it suitable to point out that 3B in the...
Speak in the mic, speak in the mic.
Oh, sorry. Yes, at 3B, in the brackets where we have including an adult correctional center if the child has attained the age of 14 years. I'm not sure, it's my view that it's not strictly necessary, because in subsection 4, it also outlines that where children are under 14, they can be placed in an adult correctional center. So those brackets, that bracket.
Which bracket remain?
In section 3B.
Or the closing remarks? You mean on such condition as the minister may direct?
Yes,
including
an adult correctional center if the child has attained the age of 14 years. But for instance, for 4A, subsection 2, where a child is under the age. So this outlines that this would only be, as it relates to children over 14, this suggests that only those children over 14 can be placed in an adult correctional center, right? But where it speaks to children under 14 years, which is subsection 4, it also outlines that those children can be placed in an adult correctional center, whether the offense is murder or whether the offense is not murder once it's on the 4th schedule. I'm not sure if I'm being clear.
At the moment, to the best of my knowledge, children 15, 16 are not placed in adult correctional center, is that correct?
But this, as it's currently drafted, it would allow for those children to be placed in an adult correctional center.
Well, this is it.
So that's why I'm saying in 3B, where it says including an adult correctional center if the child has attained the age of 14 years. I don't think it's necessary to have that, because as the current suggestions allow for children under 14 to be placed in an adult correctional center. So there's no need to make that distinction if children under 14 can be placed in an adult correctional center based on this draft.
Mr. Clark is pointing out is that the policy as is reflected here is that any child, no matter what age, can be sent to an adult correctional center. And I think what he's alluding to is whether this clause that we are looking at appropriately reflects the policy of the government, that children, no matter what age, 10, whatever age, can be placed in an adult correctional center. And that is why you're pointing out that the distinction does not really exist, because no matter what age they are, once they are sentenced, they can be put in this adult correctional center.
Almost. Well, almost, because subsection 4 speaks to the 4th schedule, which includes the offense of murder, and subsection 3 speaks about, for all intents and purposes, capital murder, right? Which is also a form of murder. So this is what subsection 3 is saying, that for capital murder, this would suggest that only children 14 and above can be placed in an adult correctional center. But then when it goes on to subsection 4, it then states that children who commit an offense under the 4th schedule, of which murder is one of those offenses, they can be placed in an adult correctional center. So there is a level of dissonance between the two subsections.
CPC, is this section 78 from subsection 1 to 4 is just repeating what is there?
It's what is currently in the Acts, Chair, and I'm not seeing a dissonance because what is in 3 is talking about the child who has attained the age of 14 years, and in 4, you're dealing with a child that the court not only that had the child committed an offense in the 4th schedule, but the court is of the opinion that none of the other methods in which the case may legally be dealt with is suitable. So I do think that the two provisions are consistent.
You know, what is happening, colleagues? No, just a second. Hold a second here, Senator Motley. Yes, Senator Binns. Yeah.
Right. Chairman, I was just saying that from my experience, and I see my former colleague at Children's Advocate's Office here in a different hat she's wearing. But from my experience, my understanding is that the general rule is that children are not placed in an adult correctional center. So that's the general rule, and that's the policy. But there are instances where perhaps given the case, the gravity of the case, or maybe space allocation, then those children are placed in adult correctional center. But there are certain conditions upon which they have to be held. For example, they have to be held in a separate area than the adults. They can't interface with the adults. So I think that, whereas I understand where the concern is coming from, there is a general policy, but there are instances where children are actually placed in adult correctional center. And I believe that the word in bracket here considers that there may be those instances, and that is why it states there, because of the very express provision that is stated at 78(1)(b).
Here's a concern you see. I come into you. To the best of my knowledge, what CPC has done is to put back sections 1 to 4, which is the present position. But she wanted to, because if we do some adjustment to the new subsection 5, then it has affect subsection 1 to 4. That's my understanding, CPC. So what we should do, first of all, is to look at subsection 5. That's the new subsection 5, which is really what we were concerned about in terms of a sentence for murder. Yes.
Well, not just 5, because in 4, in the new 4 as well, there's the new proposal to accommodate non-capital murder in the case of the child who is under the age of 14.
So basically, we should really be making some decisions on 4 and 5 and see how it would affect 1 to 3. Because 1, 2, 3 are basically what exists. Am I not correct? So 4 and 5 are new to the Child Care and Protection Act. Is that correct, CPC?
Not completely. 4 reproduces some of what is already in 78, but the new provision there has to deal with the sentence that could be imposed in the case of non-capital murder, which is currently not provided for.
All right. So, colleagues, I think we should look at 4 and 5 and make some decisions on 4 and 5, and then we determine how it may affect clauses 1 to 3. Yeah, go ahead.
Sorry,
Mr.
Chair. Just one more quick comment I find suitable to mention. So at subsection 3, we mention the offense of murder, for which a sentence of death can be imposed, and then any other offense for which the sentence of death can be imposed. But on the subsection 4B, there's only a focus on the sentence of death for this, only a sentence of murder for which death could be imposed, but we don't have that similar provision of any other offense for which death could be imposed. Yeah, and the top of page 2 speaks of 3.
Okay,
And
so
the top of page 3 speaks to, for all intents and purposes, non-capital murder, but not other offenses for which a sentence of death could be imposed. Because remember, I suppose it's for posterity, but subsection 3 speaks to A speaks to murder, speaks to an offense of murder for which death could be imposed, and then 3B speaks to any other offense for which the offense.
Let me try to clarify this. Looking at clause 4, where the child is under the age of 14, subsection A, if it is not murder, the sentence must not exceed 25 years, which is the existing position. Is that so? That's the present position.
Yes, that's the present position.
Right. So we're not troubling that. That is
no,
what
we're not troubling that.
So we can remove the bracket there. The present position not exceeding 25 years, where it is not murder. However, now, where the offense is one of murder, for which a sentence of death could have. Now, this is capital murder.
Yes.
So that B1 is dealing with the offense of murder, capital murder.
Yes.
Okay? All right. Been imposed, and the court is of the opinion that none of the other methods in which the case may legally be dealt with is suitable. The court may sentence the child to be detained for such period of not less than nor more than as the court may determine. The position and is subsection 2 dealing with non-capital murder, CPC. So B1 is capital murder, and is B2 non-capital murder. Agree? No. So colleagues, what we have to determine here is that B1, where death is a possibility, which we know would not be imposed because it's a child. So the question we must ask for a child, what is the maximum sentence that should be imposed? And also, what is the minimum where it is capital murder? And in subsection 2, the court is of the opinion that none of the other methods in which a case may legally be dealt with is suitable. The court may sentence the child to be detained for such period of not less, not more than, as the court may determine. So we're dealing with 2 types of offenses. In 1, it is capital, Roman 1, and in 2, non-capital. Fine. So we have to make that variation so that in sub 4B1, where the child, and this is a child 14 to 17, okay? Because it is under the, yes.
Mr. Chairman,
yes,
Senator. It's at 14 to 17. This provision is for the child that is under the age of 14. The child that is above would have dealt with that.
You're right.
Right. So the considerations are under 14, where it is capital murder, and not just that it is capital murder. It is for a child that is under the age of 14.
CPC, I don't know why we made that distinction for the child under the age of 14. Why did we make a distinction between capital and non-capital? I think for both cases, we should just give some guidance to the court, a minimum 10 years, maximum 30 years or something like that. Or 20 years, 40 years, we have to make that decision. Well, one of the problems that the law has, under the age of 14, the prosecution has to overcome the first presumption that the child knows right from wrong up to the age of 14. So the prosecution has to overcome that. I think it would be unusual to charge a child under 14 for capital murder, to be frank with you. Yes, CPC.
Chair, I was simply doing what I was asked to do, which was to make a provision dealing with the child under 14 for non-capital murder. What was there before is what is currently 4A. 4B is what is due. If that's not what is desired, then it
No,
would be deleted.
because the position, to the best of my knowledge, we were looking at the offense of murder for persons 15 to 17, because we were always under the impression that, maybe I'm wrong, I thought it was under 15, but you're saying under 14. The maximum penalty was always 25 years for any offense, which is that position, right? So what we're really saying, my understanding in all the discussions, is that children under the age of 14, it was at the discretion of the court, but the sentence would not be greater than 25. Isn't that's the present position? Includes everything. Sorry. Yes, SG.
No, it's for offenses specified in the 4th schedule. It's not for any offense. As it relates to children under 14, that would have fallen under, currently under section 78.5. It was really for offenses specified in the 4th schedule, not just any offense.
And murder was not specified?
Yes, it was murder or manslaughter, treason, infanticide, a number of sections under the OAPA.
So the point
larceny
about
and gun. Yes, but it's not just any offense.
The point, though, SG, if the child was under 14 and committed murder, the maximum sentence was 25 years. Agreed?
Included in the portion.
Right. So we were not going to disturb that at all. That was the discussion we have always had. If the child was under 14, we'll leave it to the court, and the maximum sentence was 25 years. Right? So we're not disturbing that at all. So that subsection, what you're proposing, then CPC in 4B, we wouldn't really need.
Subject to the little redraft here. So what is there in 4A would be
except
that we would take out the words other than murder, since that was new.
Right, to the original position. So if we'll now look at 5, where a child has attained the age of 14 years is convicted of the offense of murder falling within section 2.2 of the Offences Against a Person Act, the court may sentence the child to be detained for such period of not less than, you see, this is where CPC, the discussion you and I had, was to deal with those between 14 and 17. You understand? So between 14 and 17. You see, between 14 and 17, this is where B1, 4B1 would deal where that child was convicted of capital murder. And then 4B, 4B2 would be non-capital murder, but that, so what we're really saying is CPC. So the discussion you and I had was that 4B1 and 2 should really be in 5.
Who relates to the child who is under 14.
No, right.
So what you wanted was for the child over
14 to
over
17.
From 14 to 17, which is what 5 deals with. But
Yeah.
it's not. It only would deal with non-capital because the capital is already dealt with in what we had in subsection 3.
To understand, I'm just trying to be up to speed. So what we're saying here is this, if I'm to understand Madam CPC as well, is that if we remove from 4A the other than murder, and we retain the fourth schedule offenses for children under 14 years, and the maximum retained at 25, it would take care of murder in both forms, whether capital or non-capital, for children under 14, since we already have a maximum of 25. And so if we do that, then we wouldn't have the need for 4B1
1 and 2.
and 2.
Right.
So we would just go now to 4, we'd just go now to 4,
To 5.
to 5, sorry, 5. We'll just go to 5 and deal with children, and deal with children 14 and over. That's what we're saying.
Right.
In terms of.
Right. But where CPC can help us,
Yes.
this is in the draft, or we can make a decision and ask her to just deal with it. Go ahead, Mr. Bailey.
Okay.
Minister, I'm thinking that if it is, we don't specifically treat with both categories. So both categories being 12 and under 14 and above 14, that there may be a lacuna, because then the court would be forced, well, for want of a better word, to revert to the penalties under the OAPA, because there isn't a prescription under the Child Care Protection Act. And that was part of the justification for specific treatment of both categories of children.
Go ahead, CPC.
For where no other method can, the court is of the view that no other method is suitable for dealing with the child. So it still leaves the case of children who are under 14 who don't fall in that category where the court thinks that there are no other legal suitable methods other than the imprisonment. So those children, I think, would then fall back under, unless you have the specific provisions here, the court would be forced to treat with them under 3, which I don't think is the intention.
My understanding in the discussion, and just clear this up, colleagues, we were not going to disturb the court's discretion and the law for children under 14, right? So we didn't want to change the law in the way for children under 14, because the maximum penalty there was 25 years.
So that's correct, Minister, but we also needed to treat with the minimum. So the maximum has been set, but we haven't set.
We were not going to we're not going to interfere. We'll leave it to the court.
But if it is that we don't prescribe it, the court reverts to what is under the OAPA. That
And
is
what
the
is that?
problem, and that is the 30 years. And that's why we have to have specific treatment of the penalty under the Child Care Protection Act.
No, but yes.
What I get him to be saying is that, notwithstanding the fact that a maximum has been established, we also need to set a minimum standard, because the court may be directed to use, not me, shall or will be directed to utilize the other provisions elsewhere. So what we are seeking to do, Chair, is again set the minimum standard, ensure that a minimum standard is established. I gather from what you would have been suggesting that we were not to have touched it for those under 14. But it's still going to apply some sort of a gray area, and maybe we would want to consider in establishing that minimum standard for guidance
No, but
for
let me
the
ask
court.
you, but SG, let me ask you when you respond. If you say the court should not impose a sentence for children under 14 exceeding 25 years, isn't that, why do we have to say, but not less than 5 years? If it doesn't exceed 25, it obviously take away any minimum. I mean, it must not exceed 25 years. Sorry, SG.
So in cases like this, rule of law says sentences, offenses must be very clear and without doubt. Same thing with penalties. We don't want to leave it up to interpretation. Now currently, the mandatory minimum for non-capital murder in the Offences Against a Person Act is 15 years. Remember, it doesn't distinguish between children or adults in the Offences Against a Person Act. So you have a mandatory minimum of 15. When it comes on to sentencing a child, the court then goes to the Child Care and Protection Act, which then says, even though there is this mandatory minimum of 15 years in the OAPA, I can't sentence this child to a period in excess of 25 years. That's the regime now. You have an issue when your mandatory minimum in the Offences Against a Person Act has been moved from 15 to 30 years. You don't want to leave it to rules of construction or interpretation. In a situation like that, it is best for the Child Care and Protection Act to indicate what's the mandatory minimum that a child can be sentenced to. So even though you have that maximum, because you have this mandatory minimum in the OAPA that applies to a child, then the Child Care and Protection Act, from my perspective, should be very clear and give the court the best guidance possible, which to me would suggest that you should have a mandatory minimum and this maximum.
But the truth of the matter is, we did not really want to even imprison, to be frank with you, even imprison a child aged 12 or 13. For the simple reason, we said it may well be that there are some of them who could be sentenced, but not more than 25 years. But there might be some who may not be sentenced to a term of imprisonment, may well get a non-custodial sentence at 12 or 13-year-old. So if we now say that the minimum should be 5 or 10 years, we might even be indicating that a 12 or 13-year-old should be sent into custody for 5 or 10 years. So that is why we were saying all along, we are looking at the maximum but no minimum. Sorry, Sen.
Thank you. Chairman, two things. I do find favor with what the Solicitor General said, because I was just looking back at the proposal from last week, and the proposals from last week generally are higher than the 25 years. So there again would bring some confusion, but also, Chair, and CPC can provide some guidance because it is a question. I wondered whether in solving this challenge, if there could be a provision in the Child Care and Protection Act that takes the sentencing regime completely out of the offense against the persons and leaves it within the discretion of the judge. So it could say something to the effect that, notwithstanding the provision of sections 1B to 1C, for example, Offense Against the Persons Act, the judge shall have full discretion on the minimum. Something along the side. I mean, I'm not a draftsman, but I'm just wondering if that is possible. So it does two things. One is that it cures the challenge you're having in terms of not making it a minimum or mandatory for under 14 to be imprisoned, but also because of the challenge that exists where most of the term here are in excess of the 25 years, and in most of the terms in the Offense Against the Persons Act is in excess of the 25 years in the Child Care and Protection Act. So I'm not sure, CPC.
This is is what these provisions would be doing without saying as much. But yes, if that is the policy for a regime which would apply specific penalties, which is intended to override the penalties that exist in OAP where the offender is a child, then that would have to be expressly stated that, yes.
To be frank with you, we can accomplish exactly what you're saying, Senator Binns, by saying that the maximum penalty is 25 years, and in section 4B, the minimum is 0 and the maximum 25. For children under 14. Children under 14. Capital or non-capital. But now, we would, for children 14 and over, we have a similar regime, but then the maximum could be life, but serve, say, for capital, 20 years, and non-capital, 10 years, something like that, to give an example. 14 and over. But I don't think I think for under 14, the maximum penalty is what we should have, 25, and the minimum should be 0.
Minister, as a suggestion, if the policy is that the court should have wide discretion as it concerns the minimum period that a child under 14 must serve, we could simply revert to the formulation that is in the Act now. The formulation that's in the Act now says, notwithstanding the provisions of the Parole Act on sentencing any child, the court may specify a period that that child should serve before becoming eligible for parole. So that gives the judge wide discretion to determine. So what we would do is simply just remove the reference to the subsection 1 as it stands now and allow it to apply to when sentencing a child under 14.
You're saying this is in all right, colleagues, we have a problem. I think we know what we want to achieve, but we're not too sure this legislation achieve it. Minister Williams, CPC, I think we know what we want, but the legislation is not reflecting.
Let us first, for the record, define exactly what we want.
All right.
And then work it from there.
And CPC to reflect.
Yes. Just to be clear, so that we are giving clear guidance into what should be prescribed. I think what we may have done is that we would have gone off indicating, making different submissions, but not giving clear guidance.
So Minister Williams, you are it's your bill. My understanding is that for children under 14, maximum penalty 25 years, but we leave it to the court discretion to impose whatever penalties and conditions on children under 14. which is the current position. So we want the current position to remain as much as possible. All right? For children 14 and above, for capital murder as against non-capital murder, other offenses, the court can impose the usual sentence, okay, as an adult. In the Firearms Act, it is 15 years, okay? Under the Firearms Act, am I right, Mr. Bailey, for 14, it's 14 and above under the Firearms Act? What is it under the Firearms Act? So even 12 and 13-year-old?
Remember, the fourth schedule is the one that, so remember you have section 78(5) that talks about the child under 14. And remember, I was trying to say it's not any offense, the offense is under the fourth schedule. So one of those offenses under the fourth schedule is any firearm offense as defined in the Gun Court Act. Anything else? So you have these specific, I guess, very serious offenses that are listed in the fourth schedule that will apply to children under 14.
I think, CPC, you want to say, sorry, you.
But at 4A, where it speaks about the fourth schedule, it's not of general application to any child under 14. It's only where the court is of the view that none of the other methods in which a case may legally be dealt with, those are all of the other orders that could be made in respect of the child under section 76.
So colleagues, what we're saying, if the child is under 14, maximum 25 years, reflect what is there now as much as possible. Agreed? I think we have been saying that. But 14 to 17, we make some decision and ask CPC to reflect it. Minister Williams, if it is capital murder, it cannot be death. It must be life imprisonment or a fixed term with a minimum sentence to be served. If it is non-capital murder, I suspect it could be the same, but the minimum sentence to be served might be less than if it was capital murder. All right? So for capital murder, remember, death cannot be imposed. So for the 14 to 17, it is life imprisonment with a minimum to be served. And we must make that decision. Or a definitive term and a minimum to be served. That's for capital murder. For non-capital murder, we can say a definitive term, not less than, definitive term and a minimum to be served. Okay? Or it can be life or a fixed term, determinate term with a minimum to be served. Are we clear? So we really have 4 decisions in both capital and non-capital. We, for 14 to 17, we give some direction. Are we right, CPC? Sorry, Mr. Simmons.
Yeah, Mr. Chair, I just want for clarity. When you're dealing with children, they're not going to be sentenced to death.
Right, so we have excluded that.
So the only option really is life imprisonment.
Or a determinate term.
Yes, but even...
No. For capital murder for adults, it's either death or life imprisonment.
Correct. For adults.
Right.
But for children...
We are saying life imprisonment or a definitive term. With a minimum.
And that minimum is a minimum pre-parole period, pre-parole sentence.
Minimum mandatory to be served before parole. And for
And for
non-capital,
non-capital,
life too, or another a determinate term. But it
so
may
it will
be
be the same for both capital and capital.
you're right, but in
it's
the
just that
case
the
of
minimum parole
non-capital,
period is what is different.
might be different. Okay. All right. So let's hear from Senator Gail. All right. So let's hear from you then. Well, Minister Williams, what would be your Minister Williams? What's your proposal then? We're no capital, non-capital. What would be your proposal for the maximum? Well, the maximum is either life or what would be your fixed term for capital? Is either life or, remember, we're dealing with 14 to 50 to 17. 14 to 17. To turn on your mic. Turn on your mic. Yeah, Senator Gail, we're going to ask you to, and everyone, to see if we can get to a consensus. For capital, it is life or a determinate term, and then we decide what is the minimum mandatory to be served. This is for 14 to 17. And then for non-capital, same, life or determinate term, but we look at the, bear in mind now, for adults, for capital murder, it is death or life. With a life is either without parole or minimum 50 years. For non-capital, it is life or maximum 30 years with a minimum to be served of 30 if it is life, 20 if it is determinate. The original position in the bill at the moment, it is the sentence being proposed is a period of not less than 20 years before being eligible for parole, for capital. I think for both, but we wanted to make a separation with non-capital. So we are looking at 14 to 17. I would say, I give you my position. No, let's hear from Minister Williams first.
For capital murder, Mr. Chairman, for children 14 to 17 years, life or fixed term of 50 years with a minimum of 30.
So life or 50? Not exceeding 50, maximum.
Right.
But what would be the
minimum?
For capital, what would be the minimum to be served before parole, Minister?
30, but I hear the SG saying that's more than adults.
No, this is capital. Remember, capital, it is life for adults. Sorry? No. So it's life or a determinate term for 14 to 17. Remember, it's not necessary that they're going to serve. The question is, what is the minimum to be served if it is life, Minister?
30 years.
Remember, the proposal was 20 years, you know. No, remember the original position is 20 years for children, 14 to 17, for capital.
Well, remember, Mr. Chairman, we were still determining the demarcation with children and all of that. So the clarity wasn't exactly there. There's greater clarity now. And we do know that children between the age of 14 to 17 do commit capital murders.
So you would say if it is life imprisonment is imposed, they must serve 30 years before being eligible for parole. And if the sentence was, say, maximum 50, they must serve still 30 or? Is that your position?
Chairman, yes, Mr. Chairman.
So you're saying that once the child is convicted for murder, they must serve at least 30 years, whether they get life or 50. Remember the bill had said 20, so you want to move it to 30. Donovan. Turn it in.
Yes, Mr. Chair. I am somewhat inclined to side with the position in the bill of a minimum 20.
So life or 50 with a minimum 20 serve minimum before
Yes.
parole. Okay? All right. Senator Gill.
I am going with what is proposed in the bill.
Okay. Senator,
I'm abstaining from
abstain.
this.
Senator Binns.
Sorry, Chairman. Chairman, I really do not have a basis to give an opinion on this after I considered all the arguments that have been proffered and hearing the minister's proposal. I do need some time to think through this again.
We have to finish up today. Senator Binns. I don't know if Senator Charles Sinclair and Senator Golden Campbell, if you're with us, can you give us your views?
I'm here, sir, and I'm going with what is contained in the bill.
Okay.
That is correct.
Senator Golden? She's not? Okay. I would go along with the bill. Would you come with us, Minister Williams, 20 years? Life or 50 years? But in both instances, serve a minimum of 20 years before eligible for parole. You would go with that, the consensus. Then we're going down to non-capital after that. So,
Mr. Chairman, I know the bill had 20 years in it, and we've sat and listened to all the presentations. We've seen the figures that children in the age range of 14 to 17 do commit murder, capital murder. Yes, right now when you look at the figure and you compare it to other things, it may seem like a small percentage, but remember, it's what it is today. We don't know 5 years, 10 years down the line what it will be, and we continue to be very soft in our sentencing of people who have committed heinous crimes, capital murder. I mean, in this age, 14 to 17, this child is on the doorsteps of being an adult, knowing right from wrong. It is, you cannot imagine the pain of the parent who lost her daughter because a child in this age range brought an implement to school, stabbed her, and killed her. And we're sitting here just being really, really soft and not sending the strong message that we're not going to tolerate the crime in this country.
No, Minister Williams, bear in mind, I think we're all agreed that the sentence can be life or 50 years because that person may well never see road again. if they get life. Or 50 years, they may not see road again until they're 64, if they get life. 1 second. What parole offers is that if after 20 years or 30 years of use suggests that they are a different person from when they entered the prison, they could be allowed to continue their sentence up to 50, they got a determinate sentence, or continue the rest of their life serving their sentence in the community. But at any time they breach the parole condition, they could immediately be returned to the prison. So what we're really saying is that why I would favor a lesser term, because remember, for adults, we have said it's 40 years. Even if you get parole, it's not before 40 years. But for a child of 10 to 14 to 17, we hope, say within 20 years, it's a different person who would still be serving the sentence in the community. And in the unfortunate situation, they breach the Parole Act, they're back in the prison. So they're really serving their sentence in the community. So I think you'll appreciate when you say them. Yes. They're not free. They're not free. But on the condition, for instance, the condition may well be, let us say the offense was committed in Westmoreland, to use a bad example. You must never visit Westmoreland. So that could be a condition of your parole. You must not go to Westmoreland. Or it could be that various conditions are imposed on parole, which if they're breached. And the good thing about parole that has happened across the world, including Jamaica, is that most parolees are aware that the slightest breach, they're back in custody. And that is why you have almost a 90-odd% success for parole, because they are constantly checked on by social workers once they are on parole. So I don't know, Senator Binns and Senator Motley, if you will come with the 20 years, which is what is in the bill, the proposed bill at the moment. So we can leave the, all right. Let's go to the non-capital and then we'll come back. So the non-capital is either life or a fixed term. So in the life non-capital, the sentence might be, the offense might be quite egregious and the judge may well impose life, no problem. But the minimum sentence that should be imposed on a child, 14 to 17, for an adult, we have put 30 years, okay? The minimum sentence. Bearing in mind that the child, we should, in my view, maybe put a lesser period of minimum mandatory in the prison before they get parole. Then the question, let us say we put 15 minimum mandatory. And therefore, they would have to serve another 15 years in the community if we put 30 as the determinate sentence. So it's a matter for us to make that recommendation to Parliament. So for non-capital, it's life, and we can put a minimum or a fixed term with a minimum. So let's hear, colleagues.
What are you proposing, Minister?
It's for us.
No, but...
It's Minister Williams' bill.
So, well,
let us hear from Minister Williams.
should probably be the one to put the proposal. I forgot it was her bill.
You want to, you ready, Minister Williams? It's life, not a fixed term, minimum term. Not a maximum, it's a minimum year. Yeah. Bear in mind, for adults, it's life or 30 years for adults. And also, if life was imposed, the minimum mandatory to be served, our proposal was 30 years. But if a fixed term was imposed of 30 years, they would serve 20 years before being eligible for parole. That is for the adults, yes. You wanted to? Sure. Sorry? No, for adults, non-capital, it's either life or a minimum of 30 years for the fixed term. And if life was imposed, they must serve 30 years before being eligible for parole. If a fixed term was served, no, we changed it. No, for non-capital, you know. It's 40, we put, okay, if life was, I'm sorry. But if, so it's 40 years if it was a life for non-capital. And if a fixed term was imposed, it couldn't be less than 30 years. No, the sentence couldn't be less than 30. And they must serve at least 20 years. So that the minimum could be not less than 30, but it could be 40. But if 40 was imposed, they must serve at least 20 years before being eligible for non-capital. That was what we agreed to last week. So we're looking now at children 14 to 17. And
adults, the minimum is 20 years, right?
No, for life. The minimum is 40 years.
The minimum is 40, but for a fixed term,
right,
the minimum would be 20. The minimum is 20 years currently.
But bear in mind, we still haven't signed off as yet on the capital, since there are various proposals for capital. But we want to see if we can juxtapose them and get to some consensus. Senator Sinclair and Senator Sinclair, sorry, bear in mind we're coming to you shortly. Yeah, go ahead, Senator.
I had put a minimum of 15, Mr. Chair. And I don't know if you're reading my mind, but if you're going with the determinate 30 and 15.
So you would, for non-capital, you would have life and a minimum determinate of 30, and in both cases, they must serve at least 15 years before parole. That's your proposal?
Yes.
Okay, Minister Williams, you ready?
20 years minimum for adults, right? I'd go with a little bit of a differentiation for a child.
15?
15, yeah.
Like Senator Sinclair. So it's life or a minimum determinate sentence of 30, but in both cases, they must serve at least 15 years before parole. You're with that, Donovan? Senator Gale?
This we're talking about non-capital.
Non-capital.
For me, the minimum would be 15.
We agree on that, yes.
And for the maximum, I'm putting it at 25.
No, not maximum. Minimum, minimum. In other words, so for a child, you would go with minimum life.
Yes.
Or not less than 25.
No. My minimum is 15.
To be served.
To be served.
In both cases.
In both cases.
All right. So it's life, or what would be your minimum determinate sentence? Both 3 persons have said 30 years so far, which is really what it is for the adults.
So I am not prescribing to have the same for the adult. For someone who is below the age of 17.
No, 1 second. Let me just, please, for adults, for non-capital, it's either life or 30 years minimum. If you got life, you must serve 40 years before eligibility for parole. If you got a determinate sentence, you must serve 20 years. But the minimum sentence you can get for non-capital as an adult, 18 and over, is 30. It could be higher. But whether it is 30 or higher, you must serve 20 years before eligibility for parole. Okay, Minister Williams? That's what we agreed last week.
Just to be clear, what are we seeking to determine for the child?
For the child
at age 17.
14 to 17 is either life or a determinate sentence, and 3 persons so far said the least determinate sentence should be 30 years, but in both life and 30 years, they must serve 15 years before being eligible for parole.
And so that's why I had prescribed for the 25 and the 15 being the minimum.
No, okay, that's your proposal.
Right. Yes, it's 25.
Mm-hmm. Senator Binns and Motley, any views?
Chair, I've taken into account all the submissions which have been made before us and the overwhelming preponderance of views that incarceration is not really what is advisable for children. I have taken note of what I observe happening in the society, where children really seem to have not got any values, any attitudes, any space in which they have grown to have an opinion as to what is proper conduct in certain circumstances. I take also into account the fact that the experts have said that at that age, they're really not able to make a considered decision. They don't evaluate it to know right or wrong. And all of that. I know that the government, the minister who has control of this bill, is determined to send a very strong signal to the society. But I also think that one must consider that sometimes they are not the ones who have created their own circumstances. In fact, the society contributes very heavily towards the kind of child, the kind of Jamaican that we are producing. So I looked at the Firearms Act, which we have been using as a standard, as a measure, and the minimum mandatory of 15 years, which has been prescribed there. And then I go to the fixed term sentence of 10 years. And
no.
This is
Fixed term.
I'm looking at the DPP's opinion to cull from that what she has said takes place at 1018B. And she says that where the Act prescribes a minimum term of imprisonment, the court shall specify a term of not less than 10 years that the offender shall serve before being eligible for parole. And I'm adopting that position. And so I'm suggesting that the minimum that a child should serve before being eligible for parole is 10 years. Bearing in mind that the whole thrust of policy is to try and rehabilitate that child. Bearing in mind, Dr. Shetty says that most of them have mental conditions and 83% of them are illiterate, which means it's not really their fault, but the society has not provided this sort of guidance and prepare them for adulthood. So I'm suggesting the 10 years.
But you go life, and what would be your minimum determinate term? You mentioned
My
10
minimum determinate is the 10 years.
No. But
I'm saying that I use this as a guide to come to the 10 years. In other words, other persons have said...
No, is the 10 years your minimum determinate or your minimum time mandatory to be served?
The minimum mandatory.
So what would be your minimum determinate?
I haven't reached there.
Yeah, we need to reach it shortly. Senator Vince.
Chairman, I think the submission of my colleague is compelling, so I will go with what she's saying in terms of the 10 years, only because she has set out the reason why she's recommending 10 years. But outside of that, Chairman, I really have I do not have a timeline that I would recommend for children, because my own view is that when it comes on to children, then the focus should be on rehabilitation. And we also have to bear in mind our own obligation on the Convention on the Rights of the Rights of the Child. So my personal view, Chairman, is I don't believe incarceration should be, but if I were to find a middle ground, then I would go with the recommendation by Scott Motley based on the authorities that she cited.
All right, the 3 persons so far, 4 persons so far, no, 3 persons have indicated 30 years determinate and 15 years minimum mandatory. 4 persons, 15 years minimum mandatory, okay? Senator Motley has indicated 10 years minimum mandatory sentence, but not yet decided on the minimum determinate sentence. Senator Binns still undecided, right? Sorry? The 10 years, but what would be yours and Senator Motley, minimum determinate? Minimum determinate. I think the problem I have with the 10 years, Senators Motley and Binns, is that under the Firearms Act now, the minimum mandatory to be served for firearm offenses is 15 years. Even if it is a 14, 15, or 17-year-old. So that I don't think it would be appropriate to go below the 15 minimum mandatory, which is what exists with the firearms offenses. So I'm going to go...
Used the release which was sent by the Director of Public Prosecutions as a basis for the recommendation. And in that, she has pointed out that in contesting this sentence, which was imposed of 15 years, she pointed out that it really ought to have been, in those circumstances, 10 years. That was her view. And that is why I proposed the 10 years, because if she's correct and she's going to appeal to the court, that is what it will actually emerge, that there was a caveat in the Firearms Act at 1018B, which pointed it to 10 years.
Yes, Mr. Bailey.
So my understanding of the provision under the Firearms Act that the DPP would have made reference to, it's where a mandatory minimum had not been prescribed in the penalty section of the offense, then the court must apply the mandatory minimum of 10 years. But generally, as it concerns possession, what would have been prescribed is 15 years as a mandatory minimum. But as a general policy, if a mandatory minimum isn't prescribed and the sentence is life imprisonment, the mandatory minimum should be 10 years.
All right. Here's a position. I'm going to just sum it up, colleagues. And this is for the report and also for the CPC to reflect it. So, colleagues, just listen carefully. In relation to children under 14 years, we try and reflect as much as possible what exists in the present law. For 14 to 17, for capital murder, it's either life or a fixed term, not less than 50 years. 50 years, right, for capital. But the majority is of the view that the minimum mandatory should be 20 years. One person, the Minister Williams indicated it should be 30 years, and two members are undecided. Okay? In relation to non-capital murder, it's either life or the majority is 30 years. Senator Gale's position is 25 years. Two persons undecided as to the minimum determinate sentence. And in relation to the minimum mandatory to be served, the majority is 15 years. Two Senators Binns and Motley suggest 10 years. Okay? So what CPC you could do is to put those in brackets. Okay. Sorry?
Sorry, Chair, when you say the mandatory minimum, do you mean the parole period?
Yes.
Okay.
So let me repeat again.
And what that is meaning eligibility for parole, which does not mean you will actually get
that is correct.
Okay.
That's correct. Right. And as we said, even if you get parole, you could still, it's on condition to serve the remainder of your sentence. So CPC, what you want the bill to reflect is to repeat for 14 to 17, for capital murder, life or a minimum determinate sentence of 50 years. And in both cases, no parole before 20 years for capital. For non-capital, it's either life or the majority is 30 years determinate sentence. And again, the majority 15 years before minimum mandatory sentence before parole, 15 years. In the case of the non-capital, there is a majority. Senator Gale determinate sentence would have been 25. Senator Binns and Motley are not abstain on the minimum determinate, but would use 10 years before parole. Agreed? So that's for the report. So in the bracket, we'll put the majority position and let, when colleagues, we come back just to sign the report and to review the bill and to confirm the minutes. So we want to do that when you reckon it with 2 weeks? So colleagues, what we're looking at a very short space of time to just sign the report. We'll circulate it, and also to sign off on the bill that would go to Parliament in all cases. Okay. No, we're going to circulate it, and then that's the meeting that we'll review the draft report and sign it. Sorry.
I have another point to raise as it relates to 78.1, where it says that a child shall not be sentenced to imprisonment. But we actually do have, well, I found a law that, so the Criminal Records Rehabilitation of Offenders Act uses that language, talks about a child, well, a person under 18 who has been sentenced to imprisonment. But this act, which is mimicking, which is coming from what's there now, speaks about a child not being sentenced to imprisonment, because what the CCPA tries to do, to me obliquely, is to say that a child is not sentenced to imprisonment, but they're sentenced to detention, a period of detention. But I'm just saying that I found two laws where it speaks about a person under 18 being sentenced to imprisonment. So
which includes 14 and under.
The Criminal Records Rehabilitation talks about the rehabilitation period, and it for a child under, this is section 5 big A, a person under 18. It gives two different periods, but it links back to 3.3a, where you talk about either doesn't include a term of imprisonment or it includes a term of imprisonment. And then it bases it, depending on the term of imprisonment, that is how you get to the rehabilitation period. But if the child is not sentenced to imprisonment, then how will this apply?
But when you say not sentenced to imprisonment.
Remember, look at 78.1, a child shall not be sentenced to imprisonment.
No, bear in mind, this is where the law exists now, we're not troubling it, is that?
I know, but I'm saying that I'm looking at it and I do see a concern. Because in one instance, we're saying a child shall not be sentenced to imprisonment. But in the Criminal Records Rehabilitation of Offenders Act, it speaks of the rehabilitation period and uses the context that the child has been sentenced to a term of imprisonment. It doesn't say a period of detention. The Gun Court Act also does it, but the difference with the Gun Court Act is that it takes it out of the remit of the Child Care and Protection Act. It says notwithstanding anything to the contrary. So, okay, let me tell you what my bigger question, because we haven't been able to do the research. Is there any other law that speaks about a child being sentenced to imprisonment? I ask because the Child Care and Protection Act, no, the amendment before you speaks about, except as provided in this section, a child shall not be sentenced to imprisonment. I am wondering if it should also refer to any other law. So it's not just in this section, but if there's another law that sentences a child to imprisonment, because I don't know. I have not been able to do that research. And as I said, I have seen, why would the Criminal Records Rehabilitation of Offenders Act use that terminology?
May I just say, SG, this is where the law reform department will have to take cognizance of this. In other words, with due respect, SG, I'm glad you brought it up, but law reform must look at it. Our main concern is with the offense of murder. So what is you're looking at is what exists in the law now, which SG said.
Mr. Chairman?
Yes.
Yeah, just
yes, Senator Campbell.
It sounds to me as if the Solicitor General is suggesting that if we do not take note of it, we may be passing something that is in conflict with existing legislation. Is that what you're saying, Sergeant?
No, no, no. We're not troubling.
No, I just wanted her to clarify this.
No, to be frank with you, our position is that we do not want
No,
to.
Mr. Chairman, not our position. I'm asking the Sergeant to clarify what she just said.
No, no. What my understanding of what SGS just said is that what exists in the Child Care and Protection Act now is inconsistent with what is in the Rehabilitation Act. Is that right, SG? Go ahead, SG.
I have a suggestion then.
Let's hear it.
Which is that the committee could make a recommendation and ask the Ministry of Justice.
No, this one is education.
No, the reason I'm suggesting the Ministry of Justice is because it does involve the Criminal Records Rehabilitation of Offenders Act, and there is also an issue with Section 8 of the Gun Court Act.
So, Sergeant, it's not as inconsistent. It's not a conflict. It just may be an inconsistency. I didn't hear the first part of what you said.
You have the Child Care and Protection Act that says a child cannot be sentenced to imprisonment, but then you have other laws that seem to suggest that a child could be sentenced to imprisonment.
But ultimately, in practice, isn't it manifest as the same thing? The language may be different, and it may have some nuances.
Not really, because if you go through the Child Care and Protection Act, it tries to make it clear that a child is not to be sentenced to imprisonment. A child is to be sentenced to a period of detention. And it uses that formulation. No?
Well, yes, Mr.
I think I'm not clear on the comments that the SG is making. So I think, as Senator Golden was saying, we should just ask SG just to clarify which section she's referring to, and in both the Criminal Records Rehabilitation Act and the Child Care and Protection Act.
I'm just wondering, SG, in the Criminal Records Rehabilitation Act, where a child is mentioned there, if we're not just looking at children 14 to 17?
It says, it's section 5 big A, I said it before, and 5 big A refers you to section 3.3. And 5 big A speaks of a person under 18 years of age.
Right, I accept that.
And then it speaks of the rehabilitation periods. You have to go back to either 3.3A1 or 3.3A2.
Right, but SG, to the best of my knowledge, the Rehabilitation Act deals with persons who have been sentenced, and children under 14, I don't think their sentence is recorded. Isn't that so, Mr. Bailey? Children under 14.
So my understanding is that children don't have a record, Minister.
That's right.
Yes.
Even for the offense of murder, Minister?
No. For under 14, I don't think children under 14, there's any recording of any offense. That's the position, Senator Golden.
And that pertains, Minister, even when they transition from the juvenile system into the adult penal system?
If they're under 14, I don't think it's recorded in the criminal records
No,
office.
they don't transition till they're 18.
Right.
But if that sentence was handed down when they were 14, when they transition at 18, if they have a longer period of detention than 4 years, does the record keeping, do they then attain a record at the 18-year-old mark?
To be frank with you, I'm not too sure if it carries over into the adult correctional center, whether it is then recorded when they go to the adult correctional center. Then that's when it starts to be recorded.
Yeah, I think I'm just trying to reread the drafter's draft on the amended sheet. It says, except as provided in this question, as provided in this section, the child shall not be sentenced to imprison, shall not be sentenced to be imprisoned. So it means that otherwise, the child shall not be imprisoned. Is that what you're saying?
The except as provided in this section is there because there is unlimited. The cases where the sentence of imprisonment for life or the alternative sentence of a fixed term would be a sentence of imprisonment based on these provisions. So those are the possible sentences of imprisonment for children.
But Chair, what I was saying is if I've noticed the terminology elsewhere, I don't know that anybody has done research to ensure that it is nowhere else. We have only said except as provided in this section.
I don't think we can go beyond that.
Correct. So which is why I'm saying, I'm not saying it can be solved here, but perhaps the committee would want to make a recommendation. If you say it's not the Ministry of Justice, but somebody should undertake some research because the language used, because it does appear in the current Child Care and Protection Act. And the concept seems to be you do not sentence a child to a sentence of imprisonment. They are sentenced to a period of detention, and that was even reflected in the Juveniles Act. So
Law
there
reform
is a distinction.
Mr. Simmons and Ms. Wright, can I beg you to have a look at that? And then, colleagues, we have to close off. Please have a look if you can bring us up to date if possible. Right. Yes, we have to leave now, colleagues, but we're going to have one. This is the final discussion. It's just to.
Minister.
Yes.
Is it possible that issue you're asking law reform to look at? Is it possible for us to have an online meeting just on that singular point when they find what they find, or for them to send us something?
No, we can. When we set the next meeting, colleagues, it could be online just because we have got permission.
Okay.
So what we're going to do, as soon as the secretary indicate that the report has been drafted and Ms. Grant indicate that the views reflected there is available, we will ask for an online meeting, okay, a virtual meeting, which we hope will be sometime next week.
Mr. Chairman.
Yes.
Quickly before you close, and I know it was not part of the bill, and I don't know if it can be considered in this GSE, but with what happened in Montego Bay last night, where 2 children were murdered.
Yesterday.
Yes. And we have been seeing this across the country where children have suffered this particular fate. And I was reflecting on what we have in our current legislation in respect to what is considered as capital murder, where you have incidents that occur against particular persons, police, judiciary, and in certain circumstances. Would it be possible, I don't know if this GSE can consider it, but for the murder of a child, whether that could be brought into that category?
Well, I think Senator Sinclair,
yes,
the penalties, in my view, the judiciary could use the penalties. And, you know, the murder of a child should be deemed an aggravated circumstance.
Yeah.
And I would imagine where a child is murdered in such gruesome situation as occurred yesterday, 2 children, that once we apprehend that offender, they never see the road again. They should get...
Suppose it were one child.
Even if it's one, life imprisonment without parole. So that my view is that, you know, the killing of children is so gruesome, bizarre, and terroristic, if you want to put it that way, that once gangsters or anyone murder children, the penalty really should be life without parole. So that those persons should really feel the full brunt of the law. And that is the signal that should be sent. Yes. So, no, and I would say, you know, Senator Sinclair, unless there's unusual mitigating circumstances, if the sentence imposed where a child is murdered is not life without parole, then the DPP should appeal. In other words, if the judge imposed a fixed term, or, you know, even it would have to be the most unusual circumstances for a fixed term to be imposed without the DPP appealing. So once a child is murdered, it should be life imprisonment. Okay? Colleagues, I want to thank you all for... We are going to wait until the report is... We hope it could be sometime next week, and we will inform persons, but certainly within the next 2 weeks. This week, next week, if it can be held next week, definitely, you know, today is what, the 7th? Not later than the 22nd or so on, because we want to table the report and sign off and pass the law in 2023. Okay, colleagues? So I want to thank all the members for being here, and Senator Golden and Sinclair for being online. Thanks to the AG Chambers, the Ministry of Education technical team, Ministry of Justice, Law Reform, CPC for being present. I know we have given you some work, CPCs, but I know you will just reflect the position. So thanks, everyone. Can I have a motion for adjournment? So, meeting of the Joint Select Committee now adjourned. To a date to be fixed, okay? Virtual.
Watch the trend, pick up the trend. This